The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. You may be seated. This afternoon's schedule, we have two cases that are set for oral argument. The first one is Earley versus Board of Adjustment of Cerro, Gordo County et al. Second case is State of Iowa versus Donahue. And the last three cases will be submitted without oral argument. In the matter of the estate of Francis Glazer. Second case is in the interest of A, B, and others. And the final case is in the interest of WM and others. So at this time, we'll start with the Earley case. I'd like to do a quick sound check to make sure Justice Apple, who is participating remotely, can hear and that you can hear him. So we'll start with the appellant. Hold on just a minute, get my notes here. Okay, thank you, Mr. Koopmans. You may do a sound check.
Thank you, Chief Justice. Check.
I can hear you. I can hear you well. Thank you.
Thank you, Justice Apple.
Thank you. And Mr. Babinat?
Testing. Testing.
Did you hear that, Justice Apple?
I did. Thank you.
Okay, thank you. All right. Mr. Koopmans, whenever you're ready, you may begin.
Thank you, Chief Justice. May it please the court. Iowa code says that a Board of Adjustment cannot grant a variance unless the ordinance produces unnecessary hardship on the property owner. For over 80 years, this court has said that to prove unnecessary hardship, the property owner must show that unless they get a variance, they cannot yield a reasonable rate of return from their property, and that the ordinance produces unique circumstances to their property that are not similar to the neighborhood in general. That rule has been reaffirmed multiple times by this court. Indeed, this court has rejected requests to loosen that standard. It is a hard standard to meet, but it's supposed to be a hard standard to meet. The court said 80 years ago in Deerdorf that variances should be sparingly granted and only granted in exceptional circumstances. This is not one of those circumstances. The Cerro Gordo County Board of Adjustment approved a variance for a pergola at a lakeshore home in Clear Lake that was 21 inches from the property line, and it's supposed to be 6 feet. 6 feet itself is not a very big buffer between properties, but given the unique circumstances of lakefront properties and the need or desire to put as much home in that property as they can, it's been reduced to 6 feet. 21 inches is essentially nothing. The board granted that variance with basically no evidence to support the normal standard, and certainly not sufficient evidence or not substantial evidence. The application that the Sauls submitted, when asked whether they need a variance to gain a reasonable rate of return on their property, they left that blank. When asked whether their plight was due to unique circumstances, they put none. At the board hearing, which accounts for just 2 pages in the appendix, the Sauls didn't show up themselves. They sent the builder who built the pergola on the property. The only thing he really had to say was that, well, it was built over a patio that was already built. I think that they wanted to have shade, and that was really the beginning and the end of the evidence. There's nothing else in the record. The district court, nevertheless—
Counsel, was there anything in the record that reflected when the patio was built? Was that— it wasn't clear to me if it was kind of one project that was completed in a very short period of time, or if the patio had been there for a number of years, and then they just added the pergola later.
There's nothing in the record about that.
Okay, thank you.
There are statements by the carpenter that suggest that the edge of the wall of the patio was made for the posts of the pergola, but that's as far as anything got to describing the circumstances of the patio. The district court affirmed the grant of the variance based upon the idea that I think the only thing that the district court said was that to fully use the patio, they needed to have this pergola for shade. Fully using the patio is not sufficient to comply with the deer door standard. And I don't know that there's anything in the record to suggest that if they don't have shade, they cannot use the patio. Court did as much as it could, I guess, in trying to sustain, but there is just a complete lack of evidence on that front. The main arguments, I think, from the Sauls have been, well, we already built it and we want to keep it. But while the issue or the principle of asking for forgiveness instead of permission might be good in some circumstances, it should not be built into the law. And in fact, it's not built into the law. In the cases that this court has decided, and multiple times, the building or apparatus, whatever at issue, has been built before the hearing on the variance. For example, in Rubel, the footings are already poured for a single-family house that was on a lot that was too small. Nevertheless, this court said that the variance shouldn't be granted. In Greenewald,
Counsel, isn't the, go ahead. All right, isn't the local members of the Board of Adjustment in a better position to decide whether to allow a variance than we are, so removed from the action?
as long as they meet the factors of the statute, yes, and they have wide discretion. I mean, so much discretion. The idea that there is not enough facts here is, one of very few cases, but like I said, there are absolutely none. The code says that they cannot just give an exception to the law whenever they want to. Instead, they have to prove, the property owner has to prove unnecessary hardship. And I don't think that the legislature or anyone would want a process to where the Board of Adjustment could grant a variance completely unmoored from that statute, because then it becomes a process of, do you know these neighbors? How do we want this to go about? There is a statute to apply, and the Board of Adjustment does not have jurisdiction to go beyond that statute.
Mr. Koopmans, in your papers, you cite this Hines article, Professor Hines or Dean Hines article, which is kind of a double-edged sword, right? Because it confirms, I think, your view of Iowa law. On the other hand, he doesn't like it. And he advocates for a change where courts would move more toward a practical difficulty standard. And he also notes that some state Supreme Courts have done so judicially. So why can't we do that?
I don't see it as a double-edged sword. It's an interesting article, but like he points out in the article itself, this court has affirmed the rule so many times that it would be difficult to overturn precedent at this point. And it goes further than that, because this has become such a matter of public policy. Not only is it in your decisions, but the deer door standard has been codified in numerous ordinances itself. So if you look in the appendix, the Cerro Gordo ordinance actually adopts the standard, the deer door standard, the reasonable return standard. So we're not just talking about common law here. We're also talking about, did the Board of Adjustment follow its own rules? And that's true across the state. So if you're going to kind of get into reshaping the law, it's better if the legislature does it. And the best thing that this court can do is to reaffirm that standard and not kind of have this, well, sometimes we're going to grant it, sometimes we're not. Really, we're just going to let these boards decide, because then the issue doesn't come to a head, and it won't come across the street for kind of resolution. So the best place to change the law, if we're going to do so, is across the street. And as Dean Hines noted, that has been tried multiple times, and he proposed a statute in his article to do so. But going beyond that, I think we can even get away in this particular case from the deer door standard and say, let's just go to the statute itself. Unnecessary hardship. If under any reasonable interpretation of that phrase, a pergola at a lakeshore house in Clear Lake, Iowa, that abuts right up to the property is not an unnecessary burden. Let me just read you. There's been a lack of, of discussion about why the pergola is needed. If you look at the application, the only thing the Sauls say is, well, it provides shade at certain times of the day. The idea that they can't fully use the patio without the shade is something that the district court created. That's not in the record at all. And let me just read you for a moment what the Sauls said in their trial brief. They said, the purpose of the pergola is to provide decorative cover for the patio. In order to fulfill its purpose in an aesthetically pleasing manner, the pergola must cover the entire patio, meaning they say it must go right up to the property line. That's at page 97 of the appendix. There is no interpretation, and I think Dean Hines, if he were to review this case, would absolutely agree, under which this variance can be approved under the unnecessary hardship standard.
Can I go back to an issue you addressed earlier that I was thinking about, which is the relationship between the statute and the ordinance here. So even if we were to do something different under the statute, there's still the issue of whether or not the county complied with the text of its own ordinance. And it's explicitly incorporated the deer door standard into the ordinance. So there would still be at least an illegality with respect to failure to comply with the ordinance, assuming we find that there's not substantial evidence of undue hardship. Is that how you're understanding how those two provisions would interact? And if not, tell me why not.
Yes, is exactly my understanding. And the ordinance is on page 240 of the appendix. And right in there, it says, "No variation in the application of the provisions of this ordinance shall be made unless and until the Board of Adjustment shall be satisfied that all of the following have been established. A, the land in question cannot yield a reasonable return if used only for a purpose allowed in that zone." One other point I want to raise, Justice Mansfield, you highlighted the other cases and other courts that have changed the standard judicially. And one of those that Dean Hines highlights is in Wisconsin. And then Justice Sykes wrote an opinion in which she kind of did away with that reasonable return standard, but still stated that the applicants have to prove that the problem was not self-created. While there is no evidence in the record about when the patio was created, or even when the house that fills up almost the entire lot was created, the burden was on the Sauls to show that it was not self-created. They failed that burden. They failed every burden you could possibly imagine.
What are the practical consequences? If we affirm this, and what's the ripple effect on Iowa law? What harm would flow from a decision that allowed this variance?
If you affirm this, then it truly does become a standard in which the Board of Adjustment can grant the variance whenever they want. So you have an unequal treatment where it depends upon how well the people know the members of the Board of Adjustment. And really it is, I guess you would call it a complete crapshoot. I don't think that's what the legislature wanted or what anyone wants. That's not the purpose of zoning. It will essentially, and it will unmoor zoning law from the statute.
Am I correct that the variance request was not contested at the public hearing, like on January 22nd of 19?
My clients did not go to the hearing. That's correct, Your Honor.
Did they have anyone there on their behalf
They
to
did
object?
not. They did not, Your Honor. And that issue hasn't been raised at any time by the Sauls. And the Board of Adjustment itself is quasi-judicial, but it's not a judicial body like this one that exists to hear disputes between two parties. Its job is to decide whether to grant a variance, a change from the law, and is supposed to do so on behalf of the public interest. And the claim here, of course, is that their action was illegal, not just that they erred, but that it was illegal. And again, the standard that we have to meet to show that is very high. This is just one of those few cases that it is abundantly clear that it's been met.
I don't think it's part of the statutory criteria to consider, but what is the harm to your client if this pergola it remains above a patio that's already been there that is not challenged?
Well, the patio has not been challenged in this action, but there's still a question of whether that patio needs a variance. That was discussed in the hearing, and actually an employee of the Board of Adjustment of the city said he believed that it did, and that the board could grant the variance for the patio if it wanted to. It did not do that. So it is not challenged in this proceeding, so I will leave it there. But even so, it's one thing to have a ground covering patio. It's another thing to have a pergola that goes and kind of looms over the property line. And again, this is at a place in which the setback requirements are already very generous to the property owners. 6 feet is not much. 21 inches is almost how I would read a book. And as my eyesight gets worse, I pull it further away. So, granting something like this creates discord amongst neighbors, which is why these setback requirements exist.
I think that's why I asked my earlier question. It may not be challenged, but at the time that the variance was requested, the pergola had already been built, right?
That's correct. And again, and so, that's been the case, for example, in this court's cases before. And I think I didn't get to the Greenwald decision in Davenport. The famous Oak Knoll house had a fence that was 6 feet tall. It was supposed to be 42 inches tall. The fence, which cost $25,000 in 1980, was, quote, 99% done when the landowner found out that he needed a variance to get it. This court said that a variance was not allowed because it did not meet the Deardorff standard. It's another thing, to think about in the greater context. We're kind of so many layers down, and in every which way, they do not meet the standard. But one other thing to think about is that the variance is not de minimis. It's not small at all. You go from 6 feet to 21 inches. This isn't an issue of where it encroached, just one more foot, and do we really have to tear it down for one more foot? It is a big encroachment, and therefore an issue which every factor of the standard should be and needs to be met.
If at least for now the patio's not challenged, could they just put a table with an umbrella stand and open up a big umbrella there for shade without getting an ordinance or a variance?
I believe that the ordinance requires something to have been built. So, I'm going to have to look back on it for sure, but I don't think a temporary umbrella would be a structure that would require a variance. I see that my time is up. Thank you.
Mr. Babinat, when you're ready.
May it please the court, counsel, your honors. My name is Adam Babinat, and I'm here on behalf of the interveners, Greg and Leanne Saul. This matter is up for further review after both the district court and the Court of Appeals found that substantial evidence existed to support the Cerro County Board of Adjustment's approval of my client's requested area variance. Now we're principally facing here two questions. The first is whether or not area variances require a different standard or should be allowed to have a different standard than use variances. And then there's the question as well as to whether there did exist substantial evidence to support the grant of the variance here at this case. To tackle that first question, though, it's important to actually take a look at the unnecessary hardship standard or test. It was adopted approximately 60 years ago in the Deardorff decision, and it's actually based off of the New York Court of Appeals decision in Otto, which was decided in 1932. And as Dean Hines discussed, the Otto decision was trying to curb an abuse of use variance approvals at the time. It just so happened that when Deardorff decided to apply it approximately 20 or so years later, they'd made the decision to apply it to all variances here in Iowa, both use and area. But the history of this test as a use mechanism is still evident within the language of the statute, or excuse me, of the test. In fact, if you look at the first element of the test, that reasonable return element, the focus there is not of, or is focused explicitly on the use of the property itself. While the petitioners here are correct that this court has been occasioned the opportunity on at least two separate chances, both in Rubel and in Graziano, to differentiate these standards and has declined to do so, we feel that the Christensen decision, which was decided in 2006, played a crucial role in recognizing this important distinction between these two types of variances.
What is your proposed standard then for area variances?
Well, we would simply adopt the Court of Appeals standard, which is sort of this recognition that the use proponent of the reasonable return is sort of presumed. Alternatively, you could adopt the practical difficulties test as well that's been adopted by neighboring jurisdictions such as Minnesota.
So how would that standard apply to the facts of this case?
Are you referring to the practical difficulties test?
Yeah.
The practical difficulties test, I will concede, Your Honor, I didn't overly review that. I was relying on adopting on the Court of Appeals standard, which is simply just let's use the unnecessary hardship test as we have today, but just lessen it slightly for area variances in order to allow for more reasonable interpretations of.
Okay, well, let's apply the Court of Appeals standard then. So how does that apply to the facts of this case? And then let me give you a hypothetical. I mean, ultimately, there has to be a standard that guides decision-making. Would you agree with that?
Correct.
So let's assume that rather than a pergola, the structure at issue is a two-story addition to the house that's 21 inches away from the lot line. So apply your proposed standard to that hypothetical.
Well, in this case, the question, I guess, would depend on whether or not the proposed structure is a viable use within the zoning ordinance mechanism.
Let's assume it is. We're just talking about an area variance where rather than a pergola, your clients built a two-story addition to their home that's 21 inches from the lot line.
Well, in that case, what we would do is we would take a look at, we would presume that the use is valid, and then we would take a look at the other two factors of the unnecessary hardship test. That being whether or not the plight of the owner itself is related to some sort of circumstance that they caused, or that there are some sort of unique circumstances about the land in question that warrant this particular area variance. So using your hypothetical, if the particular lot line was unique in such a way that necessitated moving or making an adjustment to the variance, then that standard would be met. The second component there too would be, well, let's look at whether or not this alters the essential character of the locality.
What evidence would somebody need to show to prove that that variance would be okay in that circumstance? I mean, I think you just kind of reiterated the standard and said if the standard I'm proposing is met, then it would be met. But what is the rule of decision for a board that's supposed to be acting in a quasi-judicial capacity if the standard is presume the variance is allowed unless?
I would clarify, it's not presumed the variance is allowed, it's presumed that the use is allowed. So if we look at your example, we're presuming that a single-family residential property is permitted. The question is there a necessity based off of some sort of unique circumstance? So let's say, for instance, I'm struggling to think of some sort of physical land characteristic that would necessitate moving the setback requirements of, but let's assume that there was something about the land specifically that was unique. Perhaps part of the land was extensively sloped on a hill. The cost associated with leveling it off was substantial. It's a lot easier if we just move it forward slightly. Let's grant this variance. That would be the sort of facts that would be necessary.
Let's talk about the facts of this case. What was unique about the property? Noting the application answers that question, none.
Well, in this particular case, the unique circumstances was the patio itself. The factual findings here show that the patio that this pergola was constructed into did not have a zoning permit. And it was not constructed with a zoning permit, and ultimately the Board of Adjustment made the determination that a zoning permit was not necessary for this patio. So here the unique circumstances are, we're going to allow this patio to be constructed without a zoning permit, but we're not going to allow other structures to be constructed within the same framework, even though we're going to allow this patio to be constructed.
Does it make a difference that the patio was presumably put there by the owner? Is that a circumstance self-created?
I don't believe that there's any evidence in the record to show that the patio itself was put in there by the owner.
It's in the record that the county had no problem with the patio and had approved the patio, or had said it didn't need to approve the patio.
So in the transcript of the hearing, County Administrator Robbins, one of the Board of Adjustment members asked him, did this patio need a zoning permit? And he said, well, it's borderline. We could approve one now if we wanted to. It's up to you. The presumption there when the Board of Adjustment decided to grant the variance here without modifying the request to include the patio was that the Board of Adjustment here was fine with the patio without the zoning permit. And therefore, in order to build a pergola, the structure needed a variance.
Change the facts a little. What if there were no pre-existing patio and the Sauls had gone in to ask for a variance for the pergola patio combination? Should they be entitled to that under
Under that
Iowa law?
situation, and I apologize for interrupting, but in that situation, then no. If there wasn't for this pre-existing condition here that was constructed without a zoning permit in which the Board of Adjustment, presumably approved, then the pergola variance here would not have been approved under the unnecessary hardship test, because it would have been a circumstance that was entirely within their own creation.
How do you square that with the Granawalt case involving the fence?
In Granawal, I believe that the facts demonstrate there that there was no pre-existing fence there. Yes, there was a fence that was constructed similar to here, where there was a presumption that the fence was going to be constructed and approved, but then all of a sudden we needed a variance for it. But there was no pre-existing structure there in Greenewald. Similarly, in Greenewald, there was nothing stopping the landowner there from continuing to build the fence that he the fence. It just wasn't necessarily to the height requirement that he was hoping to obtain.
Can you address the interplay between the statute and the ordinance in this case? So I understand your position that we should interpret the statute somewhat differently in light of Dean Hines's article and the footnote in Christensen, I think. But still, at least in this case, the text of the ordinance does require the Deardorff factors to be met. So how do you overcome that?
Well, in this case, the statute would preempt any county ordinance. The unnecessary hardship test is a judicially created doctrine. Was passed by the New York Court of Appeals to help try to define that term within the statute itself. And so it's well within the discretion of this court to redefine what that term means specifically for area variances here. And if the court opts to stray from the Deardorff standards for area variances but maintain it for use variances, then the County Board of Adjustment would just need to pass a new ordinance to adopt this new understanding of what an unnecessary hardship is.
If we change the standard, as you argue, are local boards of adjustment going to be rudderless?
I think they're kind of rudderless right now, Your Honor. Under the very strict standard that the petitioners are advocating for, virtually all area variances here in the state of Iowa are arguably illegal because you cannot, the use, for instance, in a property like this, the argument that the Earleys have conveyed throughout the entirety of this case is that my clients needed to show that they could not use a single portion of their property for residential purposes. Well, how are they supposed to meet that standard? They're using the property today, just as they did at the time of the variance, for residential purposes. But under the Deardorff standard, if the use is not presumed to be valid, then that standard will never be met. And that's something that Dean Hines notes. So I think at this point in time, County Board of Adjustments are rudderless because they really don't have much discretion to grant area variances. In fact, you could make the case that if you have people who want to challenge any sort of area variance granted, they could just file a writ of cert and overturn most area variances that are before them because most area variances can't meet that threshold element.
Isn't there something a little bit less significant, though? I'm not saying that the entire property has to be deemed useless, but just the word hardship. I'm having a really hard time thinking in a pergola not being able to cover the entire patio is a hardship. I think we've all gone to outdoor eating places. Sometimes there's only part of the outside area that's shaded and everybody crowds to that area. Why couldn't there be a pergola on part of the patio? Maybe I'm misunderstanding how that patio was laid out. Hardship just seems like a pretty obvious common word, and I'm having a hard time seeing how it fits.
I think that the hardship doesn't necessarily come from the pergola itself. I don't disagree that the pergola could have been designed in a way where it didn't require a variance. But the hardship itself more or less comes from the fact that we have this pre-existing patio within the setback requirement that did not need a variance. But yet, if we want to install any other structure, such as a light fixture, which is a structure under the Cerro County Code of Ordinances, they cannot receive one unless it's constructed within the setback portion.
I think that would be true, like if you wanted to change it from cement to some of those cool-looking bricks. I agree, it wouldn't really change the visual aspect from the other homeowner. But you start building up and start building out, isn't that different?
It is to an extent, but at the same time, it still fundamentally comes down to here, because of this inconsistency with the Board of Adjustment, there's this infringement on our client's property rights with respect to how they can use that patio moving forward.
Counsel, I want to go back to your statement that there's no evidence in the record about how the patio got there and whether or not that was self-imposed by the owner. Whose burden would it be to prove the variance?
That would have been our burden.
And so if there's no evidence, which way does that factor then?
That goes to a question of whether or not the Board of Adjustment's determination of substantial evidence here. I can't speak on behalf of the Board of Adjustment as to whether or not that's a con or a pro. I would agree that there is evidence in the record that perhaps the half wall or the posts where the pergola was constructed into was not pre-existing, or at least that's sort of the implication. But the patio itself, the Board of Adjustment seemed to take that, made a factual finding that that was a valid pre-existing structure.
Is there evidence in the record about when your clients, had they recently purchased this house, or is there evidence about when they purchased it?
I don't believe that there's evidence in the record of when they purchased it. There's the deed or anything along those lines were not filed. As well as the contractor who spoke at the hearing didn't testify as to that.
I'm still struggling a little bit with why it matters that the patio is already built. And here's my kind of practical concern with what you're saying is, let's assume that any homeowner in the state just decides they're going to run pavers from the back door all the way to the lot line. And they're going to use it for a couple years like that. So now they've got this patio that runs all the way to the lot line, and now they're just entitled to throw a pergola on it because it would be a hardship to deny them the use of the patio that they've been using for I mean, that's what you're saying, right? And that strikes me as odd.
And I see my time's expired. Do you mind if I answer?
Answer that, thank you.
Thank you. In that circumstance, if there was factual evidence before the Board of Adjustment where the Board of Adjustment knew that those pavers were installed by the homeowners, then that would be a circumstance that is the plight of the homeowner itself. And therefore, that variance should be denied under that second element of the unnecessary hardship test. The unique circumstances here are the fact that the Board of Adjustment made a factual finding that patio just pre-existed the pergola itself without making a determination as to when it was installed.
Thank you. Would you like to wrap up?
And just for those reasons, we would affirm the district court's decision and the Court of Appeals decision. Thank you.
Thank you. Mr. Koopmans, when you're ready.
Thank you, Chief Justice. I just want to pick up where Justice McDonald left off. The exact point I was going to make, I think we don't know in the record when this pergola or when the patio was built, but let's just go through a hypothetical and say it'd been there for 100 years. That they were the fourth owner who had used it. What they are really saying is if there's a patio, we are entitled to have a pergola on top of it. That is a hardship not to have a pergola on a patio. So that's really all you have to deal with. Is that an unnecessary hardship? I don't know any factor under any test anywhere in the country that would say that it is. The issue about whether the ordinance applies, the statute does not preempt the ordinance from making a variance harder to get. Dean Hines actually makes the point in his law review article that some cities and counties in Iowa do not allow at all use variances. So it is certainly fine for them to make it harder. So if the state were to say, we're going to adopt a practical difficulties test, that practical difficulties test still would not apply in Cerro Gordo County unless the Board of Adjustment took out the Deerdorf test from its ordinance.
I mean, here's the issue that I think Mr. Babinat raises in his argument is, I mean, are we talking about a standard that's really too strict? I mean, let's take a hypothetical. Let's say the Sauls and the Earleys got along great with each other, and the Sauls had a disabled child that they wanted to be able to have sit outside on that patio a lot. And so they wanted to build a pergola for that reason, and they talked to the Earleys, and the Earleys said, that's great, that's fabulous, we agree, we have no problem with that whatsoever. And they both went to the county, and you're saying the county still couldn't approve it, right?
I don't know. That's a close question. I was going to go exactly there next and say, how strict is this standard and when would it be met? And the first example I was going to go to is, what if one of the Sauls became wheelchair bound and they needed to create a ramp off of that door, off of the patio to get in, and the ramp encroached upon the setback requirement? To get into the house is obviously you need that to have a useful enjoyment of the house. And if you look at Greenewalt, that actually kind of converts a little bit or discusses how you convert the kind of reasonable return test to a residential property that is not made for profit. And so kind of useful enjoyment, all useful enjoyment of the property. So under that standard where you need to put some kind of ramp in to get into the house, I think it would be met. In Greenewalt itself, this court said when it might be met, which is that if they needed a 6-foot fence or the insurance company was not going to insure them, that would meet the standard. But they didn't have proof in that case because the insurance company just said, there's a bunch of these things that we think you should do, security measures, because crime is up, and if you don't do these, we might take away your coverage. So it is very difficult, but there are instances in which it will survive, and maybe it is too harsh, but that's probably a better conversation at this point after we've been doing this. I think I said 80. I was corrected. It is 60. My math was wrong. We've been doing this for 60 years. It is better that the legislature have that discussion, and the legislature doesn't have that discussion if variances are kind of hodgepodge, approved, not approved. It has to come to a head and has to be, what is the standard? What is the bright line? And then we can have a real discussion about whether it should be changed. If there are no further questions.
Thank you, Mr. Koopmans.
Thank you.
Of Earley versus Board of Adjustments, Cerro Gordo, and the Sauls is hereby submitted. We will take a brief recess for the next case to approach the council table, and that will be the case of State versus Donahue.